Hello, good afternoon. I see we have people joining us. Welcome. I'm Lisa from the Law Library, and with me today is our speaker, David Carr, who is an expert in legal ethics and the law of lawyering, with another great presentation on another aspect of California ethics rules on multi-jurisdictional practice. Today, a couple of housekeeping things before we get started, and I turn you over to David. This is an ethics CLE presentation today. As I'm sure you're aware, I will be sending out the attendance certificates this afternoon based on the report in Zoom that lets me know who actually showed up today. So be looking for that in your email. This is interactive as always. You can type your questions for David in the Q&A feature. On your screen, you'll see Q&A with 2 speech bubbles. That is a feature in Zoom that allows you to type a question in for the speaker, and you can do so under your name or anonymously, whatever you'd like to do. And then finally, there is going to be a link for a survey at the end of today's program. We always appreciate any of you who take a minute or two to take the survey. So I'm going to go ahead and disappear and turn things over to David.
Okay, thank you so much, Lisa, and thank you everyone for joining me today. We're going to spend an hour discussing multi-jurisdictional practice, which is a hot topic, a timely topic, and hopefully an interesting topic. Some of you may be California lawyers who are residing in other states. Some of you may be lawyers admitted in other jurisdictions who are in California and are wondering what are the parameters of what you can do. This presentation may not answer all your questions because the multi-jurisdictional practice area is a somewhat confusing area, and we're going to explain why it's confusing. But there is a little guidance, and there is an improving and evolving sort of national picture about what lawyers can and cannot do in other jurisdictions. So with that, I'm going to share my screen with you, and we're going to begin our the slideshow and the presentation. And basically, hopefully, we will try to answer the question of how you can be in 2 places at once with multi-jurisdictional practice. Hold on a second. Here we go. Why is multi-jurisdictional practice such a confused topic? Well, unfortunately, we have a situation where we have 50 different jurisdictions in the United States, 51 if you include Puerto Rico. And each of those jurisdictions is a separate sovereign with its own rules on bar admission and its own bar of lawyers who are licensed in that particular jurisdiction. On top of that, on top of these 51 separate sovereigns, we also have the federal government, which is also a separate sovereign. So if you're counting, that's 52 separate entities, all of whom have different admissions rules. And if you look at the federal government, you also have administrative agency practice, which have their own rules, as well as the federal courts. And each federal district court, each federal circuit court, and the Supreme Court are all separate courts with their own separate admissions rules. So at this point, I've lost count of how many separate sets of rules you as a lawyer may be subject to, but it's quite a few. And these rules, by and large, are based on geography. They are rules that date from, well, not the last century, but the century before the last century, when geography was a barrier. There was a point until Samuel F.B. Morse invented the telegraph, where most information could move only at the speed of a very fast horse. That ended in 1840, and we began to enter the age of electronic communication, which has evolved to our present state. In fact, the present state of me talking to you over a Zoom link from New Mexico, wherever you may be in the world, and you might be in California, you might be in another state, you might be in Antarctica for all I know. But if you have an internet connection, and with satellite networks now, well, soon we will have universal internet service. You can see me from practically anywhere in the world, and I can see and interact with you. So there are two basic sort of inverse problems in multi-jurisdictional practice. The first problem, which may be of interest to most of you, are California lawyers who are practicing in other states. We're going to talk about that. The inverse of that are lawyers from other states who are practicing in California. And let me say, when I say in California and in other states, I'm referring to geography now. During the presentation, we will get to the point where we're discussing the phenomenon of virtual practice. Virtual practice, which means that you may not be physically present in your body, but through cyberspace, you are virtually present in another jurisdiction. That is a concept which entered the lexicon about 21 years ago in the face of evolving communications technology. And it's something that needs to be qualified, because most of the rules in most of the states, including California, have not fully come to grips with the idea of virtual law practice. And finally, something we're going to touch on for the California lawyers, or maybe more specifically to the extra California lawyers, if you will, who are physically present in California. We're going to touch on California's tradition of protectionism. The 49ers who came and founded the state of California, my wife's great-great-great-grandfather came from Germany in 1848, was among that gold rush, and it was a rush. They came to a state that was abundant in riches. And the early settlers of California wanted to keep a lot of those riches to themselves. So those people included lawyers, and many of the lawyers who came to the Golden State were intent on marshaling its legal treasures and maintaining those legal treasures for themselves. California is still considered the Golden State for lawyering for a lot of reasons, not only its large population, but its generally liberal laws in a lot of areas. So there are many, many, many lawyers from other states, law firms and lawyers from other states, who want to come to California and, like those 49ers of yore, want to make their fortunes here on the left coast. So we're going to talk about the California tradition of protectionism and how that influences the state of the law. Okay, so let's begin at the beginning, which, as Maria reminded us, is a very good place to start. And let's look at the cornerstone of California UPL law and kind of the cornerstone of California protectionism. Business and Professions Code sections 6125 and 6126. 6125 that says, no person shall practice law in California, emphasis on in, unless that person is an active licensee of the state bar. Section 6126 goes on to tell us that any person advertising or holding himself or herself out as practicing or entitled to practice law or otherwise practicing law, who's not an active licensee of the state bar or otherwise authorized pursuant to statute or court rule. And we're going to look at some court rules that address that. Authorized to practice law in the state at the time of doing so is guilty of a misdemeanor punishable by up to 1 year in county jail or by a fine of up to $1,000. or by both that fine and imprisonment. The unauthorized practice of law, elusive as it may be, is a crime. Not only is it a crime, but it's also a practice that the state bar has the statutory power to enjoin. If you are engaged in the unauthorized practice of law, either because you're not licensed in any jurisdiction, you're not a lawyer anywhere, and you're practicing law, or you're a lawyer from another jurisdiction physically present in California and not an active licensee of the state bar or otherwise authorized by court rule. The State Bar of California can go into the Superior Court and obtain a court order essentially enjoining you from the practice of law. So that's section 6125, 6126. Hold on just a second. I'm going to have to take a short pause here. Okay, sorry about that. Sorry for the interruption. Where were we? Let's go back to the PowerPoint. Okay, we're talking about 6125, 6126. In other words, you can commit the unauthorized practice of law in two ways. You can either do things that constitute the practice of law, or you can hold yourself as being entitled to practice law. That is one cornerstone of the law of unauthorized practice of law. Another cornerstone, and we'll start kind of from the other end of things, the ABA model rules, which are the basis of the disciplinary law in all 50 states now, although each state has enacted significant differences. And we'll see when we look at California's version of this particular rule, which is Model Rule 5.5, regarding multi-jurisdictional practice. ABA Model Rule 5.5, first of all, addresses one part of the problem, the obverse problem that I discussed earlier. A lawyer shall not practice law in a jurisdiction in violation of the regulations of the legal profession in that jurisdiction or assist another to do so. That's 5.5a. That is basically the scenario that might cover a lawyer from California who's moving into another jurisdiction. The obverse part of it, 5.5b, says a lawyer who is not admitted to practice in this particular jurisdiction shall not, except as authorized by the rules or other law, establish an office or other systemic or continuous presence in this jurisdiction for the practice of law. And when they talk about presence in 5.5a or b1, they're talking about physical presence. 5.5b2 states that a lawyer not admitted to practice in this jurisdiction shall not be to hold out to the public or otherwise represent that the lawyer is admitted to practice law in this jurisdiction. This, you can see the parallelism here between ABA Model Rule 5.5 and California Business and Professions Code 6125, 6126. UPL, either doing things in the jurisdiction that constitute the practice of law. That's a very large topic that could make for a whole hour in and of itself. Or you hold yourself as entitled to practice in that jurisdiction. These concepts are cornerstones in the law of the unauthorized practice of law. Now, the ABA model rule goes on and hold on a second. Sorry about that. My mouse is a little bit sensitive today. ABA model rule 5.5. Remember, the model rule is just that, a model. It's not the law in any one state, but it is a template that other states have used to enact their laws. Contains certain safe harbors that are exceptions to the general rules stated in 5.5A and B. C says that a lawyer admitted in another United States jurisdiction and in good standing may provide legal services on a temporary basis in this jurisdiction, provided they're undertaken in association with a lawyer who's admitted to practice, are in or reasonably related to a pending or potential proceeding before a tribunal or a court in this or another jurisdiction, if the lawyer or the person the lawyer is assisting is authorized by law or ordered to appear in such proceeding, or reasonably expects to be so authorized. In other words, another lawyer who either is authorized to appear or expects to be authorized to appear. Number 3, C3 says, on a temporary basis, you can provide services that are reasonably related to a pending or potential arbitration, mediation, or other ADR proceeding in this jurisdiction, if those services are related to the lawyer's practice in a jurisdiction where they are admitted, and not something that a court requires pro hoc vice admission. Or, and here is a sort of a catch-all provision, are not within C2 or C3 and arise out of or are reasonably related to a lawyer's practice in a jurisdiction where the lawyer is admitted to practice. A good example of this is a lawyer who is admitted in California, but needs to depose a witness in Illinois. The California lawyer may travel to Illinois and may, assuming Illinois has enacted this rule, and in fact it has, take those depositions in Chicago, let's say, because those depositions are related, arise of or are reasonably related to the lawyer's practice in California. You can go outside the state of California and do discovery, take depositions, sometimes appear in other ancillary or parallel proceedings, provided they are reasonably related to your practice in California, to use an example. Subparagraph D states other safe harbors, if you will, or other exceptions to the general rules on the unauthorized practice of law. A lawyer admitted and in good standing may lawfully practice as an in-house counsel under the laws of the foreign jurisdiction. May provide legal services through an office that is systemic or continuous in that this jurisdiction, provided they're provided to the lawyer's employer or its organizational affiliates. This is the in-house counsel exception in 5.5 D1. And finally, a very significant exception, because the federal government is a separate sovereign, both in its administrative agencies and in the federal courts, a lawyer may provide services that are authorized by federal or other law or rule that pertain to an activity in this jurisdiction. The federal law exception, which is a very significant exception. Now, we've seen the ABA Model Rule 5.5 contains the basic principles about not appearing in a jurisdiction where you're not licensed to appear, and not holding yourself out as being licensed to or authorized to practice law in that jurisdiction in sections A and B. But the ABA Model Rules we've seen contains significant exceptions in subsection C and subsection D. This is California's version of 5.5, remembering that the Model Rule is only a template. California 5.5 contains the A part concerning lawyers admitted in California who will go outside the state to another jurisdiction. And it contains the B part, a lawyer not admitted to practice in California. Lawyers coming into California from a foreign jurisdiction, foreign meaning anything other than California. But California does not have the robust exceptions that are contained in ABA Model Rule 5.5C and 5.5B, although in other areas, as we'll see, some parts of California law incorporate these exceptions in different ways. California has a bare bones version of 5.5. Why does it? In my view, it's because California exceptionalism. We basically don't want lawyers from other states coming into California and competing with California lawyers. I will state my opinion, my honest opinion, that in our current society in the 21st century, where we have travel is easily accessible, the law is easily accessible. My own view is that these jurisdictional rules really serve no good purpose anymore, and they are, in essence, sheer protectionism. Unfortunately, we seem to be stuck with them, and there's no indication, although we're making some slow progress, there's no indication that we're going to have anything like national licensing anytime soon. Protectionism is very strong, although there are many lawyers who are somewhat astonishingly ignorant, if you will, about the nuances of multi-jurisdictional practice, and who rather blithely assume because they're admitted in one jurisdiction that they won't have a problem going into another jurisdiction and practicing law. This is one reason why multi-jurisdictional practice is a continuing issue and raises continuing issues for ethics lawyers like myself. Hold on. Okay. I'm going to touch on the federal exception, the federal preemption, if you will. And this is really, it is based on preemption. Two significant cases, Sperry versus Florida, 1963 case, which found that Florida could not prohibit a registered patent agent, a person registered to provide legal services under federal law, could not prohibit such a person from practicing in Florida and, in fact, opening an office in Florida for the purpose of offering patent services. In California, we have a significant case called the Benninghoff case, a much more recent case from 2006. In the Benninghoff case, the Court of Appeal stated that the Superior Court of Orange County could not assume jurisdiction over the federal practice of a former California lawyer who had resigned with discipline charges pending. In other words, similar to Sperry versus Florida, the civil courts, not only the disciplinary authorities, but the civil courts had no jurisdiction over Mr. Beddinghoff's federal practice, although the Superior Court could assume jurisdiction over Mr. Beddinghoff's state practice because he was no longer licensed to practice law by the state of California. Okay. Well, I think I've outlined the sort of the basic rules governing multi-jurisdictional practice. And we've seen that although the model rules contain robust exceptions, California does not, at least in its rules of professional conduct, contain the same exceptions. However, there are California rules of court that authorize appearance in California or the practice of law in California by lawyers who were not licensed by the State Bar of California. These exceptions appear in the California rules of court, and they're worth looking into and knowing about, especially if you're a lawyer from another jurisdiction who wants to practice law in California. It's possible you may fit into one of these exceptions. Some of them are fairly well known. 9.40 talks about counsel pro hoc vice. Pro hoc vice counsel is a lawyer from another jurisdiction, not licensed in California, or not licensed in the jurisdiction where the court sits, who is allowed on motion to appear in a court in that foreign jurisdiction. Pro hoc vice is a very familiar concept. 9.41, appearances by military counsel, registered military spouse attorney, certified law students, out-of-state attorney arbitration counsel, a registered foreign legal consultant, registered legal aid attorneys, registered in-house counsel, and attorneys practicing law temporarily as part of litigation, or non-litigating attorneys temporarily in California to provide legal services. And you'll see in some of these categories, there is a parallel between some of the provisions of ABA Model Rule 5.5 C and the California Rule of Court. These particular California rules of court that authorize these safe harbors, if you will, for non-California lawyers to appear. Let's look at a couple of these rules, some of the more significant ones. 9.46 is registered in-house counsel. Remember 5.5D, ABA Model Rule 5.5D, talks about providing services as an employee for a particular employer. California has a similar rule, 9.46, which allows a lawyer not licensed in California to apply for what's called registered in-house counsel status, RAHC. It requires an application. That lawyer may only provide legal services to that employer, who must be a qualified employer, although that lawyer must be licensed in some jurisdiction. And that lawyer must also pass a moral character clearance conducted by the State Bar of California. RAHC allows that lawyer to obtain a provisional clearance and continue to provide services to that employer as in-house counsel while the moral character application process is pending. So I have often seen lawyers who work for corporate employers as in-house counsel, who have obtained their temporary provisional clearance to continue practicing, but run into problems in the moral character application process. In some cases, problems because they have actually been providing in-house counsel services to that particular employer, sometimes for a period of years. I had one client worked for a large defense contractor in California, was only licensed in Oklahoma, and he had been working for that defense contractor for 14 years. We were ultimately able to get his moral character clearance. But that's an example of an attorney, of the phenomenon of attorneys who assume, because they're licensed in one jurisdiction, that there's no problem with them going into another jurisdiction and representing a business entity as an in-house counsel. Hold on a second. Okay, I think my slides may be out of order. Two other quick safe harbor exceptions in the California rules of court. Attorneys temporarily in California as part of litigation, again, must be admitted in good standing, may not have an office or be a resident of California. They must state on any advertising accessible in California that they're not licensed in California. Again, two concepts from the model rule: no permanent presence and may not hold themselves out. And they are entitled to appear on a limited set of activities, a proceeding in another jurisdiction where they're permitted to appear, or kind of in parallel to the model rule, and a proceeding where they anticipate being authorized to appear, for instance, an appearance in pro hoc vice, an appearance in federal court where they anticipate being admitted pro hoc vice, but they have not yet been admitted, and they need to do preliminary work, an anticipated proceeding in another jurisdiction where they expect to be authorized to appear, and anticipated or pending proceeding where the attorney supervisor is authorized or expects to be authorized to appear. Very similar to the exception in Model Rule 5.5D. There's a similar rule for attorneys temporarily in California to provide non-litigation services, transactional work, for instance. Again, must be admitted in good standing in the other jurisdiction. May not have an office in California or be a resident. No, they may not establish a presence, a physical presence permanently in California. And again, they cannot hold themselves out as being entitled to practice in California, but they may, on a temporary basis, provide transactional services. So that is the essence of most of what appears in the California law regarding the unauthorized practice of law. Our rule 5.5, again, a rather bare bones version of the model rule, and some safe harbors that appear in the California rules of court. That addresses the situation of lawyers from other states coming into California. Now, many of you, probably most of you, are more interested in the other situation, the obverse situation. A lawyer licensed in California who wants to go into another jurisdiction and practice law. And let me go back to my one slide that I see, I think is out of order. And this is a slide that's of particular interest to me because I now live and practice in the state of New Mexico. And in back of me, you can see the New Mexico state flag, the ZIA. And I am one of the many lawyer people who have left California and gone to another state for economic reasons. I'll be frank about saying. So I live in New Mexico, but I practice law in California. How can I do that? Well, I can do it because New Mexico has a particularly liberal version of Model Rule 5.5. Here in New Mexico, we call it Rule of Professional Conduct 16505. And it starts out with the basics of Rule 5.5, and including California's version, can't practice law in a jurisdiction in violation of the regulations of that jurisdiction, cannot be, if I'm not admitted here, I can't, except as authorized by the rule, establish an office or other systemic or continuous presence in this jurisdiction here in New Mexico for the practice of law, may not hold myself out to the public or represent that I am admitted to practice law in this jurisdiction. Although my application for New Mexico admission has been approved, I have not yet been sworn in by the Supreme Court. So I can't represent that I'm admitted to practice law in this jurisdiction, although I anticipate shortly I will be able to. But New Mexico has a version of the liberal rules contained in the ABA model rule. It says that a lawyer admitted in another jurisdiction and in good standing may provide legal service on a temporary basis, undertaken in association with a lawyer who's admitted to practice, or are reasonably related to a pending or potential proceeding before a court, if I anticipate being authorized. Again, a theme that appears in the model rule appears in the California Rule of Court. But the exception that I fall under comes from subsection F, 16505F2. I can provide legal services reasonably related to my practice in a jurisdiction in which I am admitted to practice, in this case, California. I can sit in California and virtually, through Zoom, through telephonic means, I can provide legal services in California, even though I am not in California, because New Mexico has a fairly liberal version of the ABA model rule. Other parts of 16505F contain the federal law exception. They contain the ABA model rule exception for services provided to a lawyer's employer as in-house counsel, F3, and services reasonably related to a pending or potential arbitration, mediation, or other ADR proceeding in another jurisdiction. New Mexico has by and large adopted ABA model rule 5.5 with a few tweaks which appear in F2. Fortunate tweaks for me, because this allows me to practice California law from New Mexico. So, bear with me just a moment. And this raises the whole topic of virtual practice. Virtual practice is something that would not have made sense to anybody until telecommunications technology had evolved to a point, as it has evolved to a point, in fact, evolved to that point sometime in the mid to late 20th century, where it was in fact possible to be in two places at once, to be admitted in a foreign jurisdiction and also practice law in another jurisdiction. In other words, to be in one place physically and in another place virtually. The first big mention of virtual practice actually comes from a California case, a very well-known case in my circles called Bierbauer. And it's an interesting case. It involved New York lawyers who came to California to do an arbitration. And they physically came into California and provided legal services in the course of this arbitration without being admitted to practice in California. The client, as clients will do, looking for a reason not to pay these lawyers, essentially stiffed the New York firm, saying, we don't have to pay you because you're not licensed in California. And the Bierbauer firm filed suit against them in California. And there was a demurrage sustained, and that demur went up on appeal, all the way to the California Supreme Court. And in 1997, I was lucky enough to actually, or 1998 actually, early 1998, I was lucky enough to attend the California Supreme Court oral argument in the Beer-Brauer case. And out of that case came this very interesting dicta. It wasn't completely on point because there was really no virtual practice issue in Beer-Brauer. The lawyers had come to New York and were physically present. But the California Supreme Court said our definition of 6125 does not depend on or require the unlicensed lawyer's physical presence in our state. Physical presence is one factor we may consider in deciding whether the unlicensed lawyers violated section 6125, but it's not exclusive. For example, one may practice law in the state in violation, although not physically present here, by advising a California client on California law in connection with a California legal dispute by telephone, fax, computer, or other modern technological means. Conversely, although we decline to provide a comprehensive list of what activities constitute sufficient contact with the state, we reject the notion that a person automatically practices law, quote, in California, whenever that person practices California law anywhere or virtually. Interesting dicta, and in fact, somewhat confusing dicta. But the essence of Beer-Brauer can be understood to at least posit, even though it wasn't really an issue in this case, the idea that geography is now obsolete, and the determination of whether you are in a state will no longer depend on if you're physically present, but it will depend on a multi-factor test, which is very similar to the multi-factor test for jurisdiction. Some of you may remember the International Shoe case from civil procedure, which talked about minimum context, the minimum context necessary for a court to assert jurisdiction. Well, now UPL essentially, Beer-Brauer's concept is, well, it's going to be a very similar kind of test. It's not going to be necessarily your physical presence. That's one factor, but it's also going to depend on what law is involved, where the client is located, what connection you have with the other jurisdiction. So Beer-Brauer was a very influential case. And in fact, those California rule of court safe harbors we talked about a little while ago were enacted in response to Beer-Brauer. So Beer-Brauer starts to answer the question about how we can be in two places at once. Now, the idea of virtual practice, obviously, during the pandemic, when many of us were restricted in our movements, the idea of virtual practice, although it had existed for a long period of time and had been gathering momentum for a long period of time, the pandemic gave the whole problem of virtual practice a new emphasis, if you will, because not only were lawyers not physically coming into the office, but some lawyers were physically not even coming into their home states to practice law. So there was a great interest in trying to bring this crazy geographic centered patchwork of 50 jurisdictions. There was great interest because of the advances in technology as to find a way to make this Beer-Brauer concept of virtual practice something that could be addressed on a nationwide scale. And you can see that the ABA, which really kind of helped to pioneer the idea of multi-jurisdictional practice. Something you would expect from a national bar association. The American Bar Association is not a governmental body. It is a private organization, but obviously a very powerful and influential organization. Its model rules have become the basis for discipline now in every state. California was one of the last holdouts, California and Ohio. But even California and Ohio now have model rules based on the ABA model rules. The ABA model, the ABA also issues formal ethics opinions that are very influential. And on December 16th, 2020, the plague year, if you will, they issued formal opinion 495, which talks about virtual practice. And the digest, here's the upshot of what the ABA said. Lawyers may remotely practice the law of the jurisdictions where they are licensed, while physically present in a jurisdiction where they're not admitted, if the local jurisdiction has not determined that the conduct is the unlicensed or unauthorized practice of law, and if they do not hold themselves as being licensed to practice in the local jurisdiction. Again, two concepts we've seen that we should be familiar with by now from ABA Model Rule 5.5, as well as the California law on the unauthorized practice of law, 6125, 6126. Do not advertise or otherwise hold themselves out as having an office, a physical presence, and do not provide or offer to provide legal services in the local jurisdiction. I'm in New Mexico, but I can't offer services to New Mexico lawyers, at least not until I take my trip up to Santa Fe and get sworn in by the New Mexico Supreme Court. This practice may include the law of their licensing jurisdiction or other laws permitted by 5.5 ABA Model Rule 5.5 C or D, including federal law or temporary practice. Having local contact information on websites, letterhead, business cards, advertising, or the like would improperly establish a local office or local presence under the ABA model rules. One aspect of multi-jurisdictional practice is the phenomenon of internet advertisement. The internet, of course, is a medium that is accessible anywhere in the world, and a corollary between multi-jurisdictional practice and the advertising rules is that lawyers who are going to establish an internet presence, and that includes just about all of us, have to be extremely careful about not holding themselves out to practice in a jurisdiction where they're not licensed. The use of appropriate disclaimers. My disclaimer states that I'm only authorized to practice law in California and Texas. Soon, New Mexico will join those two. And I'm not authorized to practice law anywhere else. That is an important thing to keep in mind. If you're going to do internet advertising, or have a website that's accessible outside your licensed jurisdiction, you have to think about appropriate disclaimers. But ABA Model Rule 495 is based on the ABA model rules, not specifically on California law. So there is an open question as to the extent to which the position taken in 495 is applicable in California. There is no official California formal ethics opinion that addresses this issue. And strangely enough, there was probably never going to be an official California formal ethics opinion that does address this issue. By policy of the State Bar of California Board of Trustees, a policy adopted in the early 1990s, our State Bar of California Legal Ethics Committee is forbidden from opining on issues involving the unauthorized practice of law. Again, part of this may be California protectionism. Part of it may be the fact that the State Bar of California is powerless to change statutes like Section 6125 and 6126. Only the legislature can do this. So there is still an open question as to the extent to which a lawyer from another jurisdiction can come into California and practice law. Now, as I said, there is no official California ethics opinion on this topic, but the Bar Association of San Francisco, again, riding a wave of impetus created by the pandemic and the pandemic lockdowns, as they've been called, has issued an opinion that is persuasive, but perhaps not authoritative. BASF opinion 2001, issued early in 2001, states what the law should be. It says a lawyer who is not licensed in California and who does not advertise or otherwise hold himself out or herself out as a licensed California lawyer, does not establish an office or other systemic or continuous presence for the practice of law, does not represent a California person or entity, but is merely physically present in California while using modern technology, much as I am now sitting in my home office, to remotely practice law in compliance with the rules of the jurisdiction where they are licensed, should not be held in violation of California's UPL law. BASF 2001 states what the law should be, but we don't really know what the law is. If such a lawyer does represent a California person or entity, whether the lawyer violates the UPL rule or laws will depend on the nature of the representation, whether the representation complies with the regulations of the home jurisdiction, the role of other California lawyers, and other factors relevant to whether the California client is protected consistent with the purpose of the UPL rule and laws. Here we have the Bierbauer concept. It's now a multi-factor test, and certain factors weigh heavily, other factors may weigh less heavily, but we're not totally sure how those factors are going to be weighed. There isn't any case law to really help us, to guide us in this yet. And finally, the BASF opinion concludes, a lawyer who's licensed to practice law in California, but who resides in another jurisdiction where the lawyer is not licensed, while continuing to remotely practice law under the lawyer's California license, must adhere to California rules and law, but must also comply with the applicable regulations of the jurisdiction where the lawyer resides. In other words, if you're a California lawyer, you're going to move to another state, as I did, it behooves you to look very closely at that state's particular version of not only Rule 5.5, but any other applicable statutory or rule of court in that jurisdiction, and do your research carefully before you make the commitment to move to another state. If you're going to come to New Mexico and practice law virtually, you're on pretty safe ground. But you really have to do your due diligence and research the laws of the state you want to move to be sure you don't run afoul. Because not only if you do run afoul of the rules in the other jurisdiction, remember under California Rule 5.5a, the California State Bar can discipline you for violating the UPL law in the other jurisdiction. And with that, I'm at the end of my formal presentation, and I'd be very happy to address any questions people have. And I see one question pending.
So David, we have an anonymous attendee who is asking
questions. I will address that question. The question is, a lawyer temporarily residing out of the country and working remotely for a few weeks, does that violate California ethics or ABA rules? And as we've seen from this discussion, we're not really sure, because it's going to depend on where the lawyer is licensed, and we don't know where the lawyer is licensed. I assume in California, and not in the jurisdiction when they're, the foreign jurisdiction. I guess this is essentially the vacation question. You're going to go to Australia for a few weeks. Can you take your laptop with you and practice California law while you're on vacation? And I'm guessing, as I think about this particular question, that the answer is probably yes. You probably can virtually practice law on a temporary basis while you are in Australia or wherever. Although I probably want to have some idea of what Australian law was before I ventured to fully broach an answer to that question. Another question: are there any opportunities for out-of-state attorneys to do legal services work, documentation prep, based on the new permissions for legal document preparation or paralegal service permissions? I think the answer to that question is yes. These are not the practice of law, provided that you don't hold yourself out as entitled to practice law, and you follow the paralegal, the rules regarding the permissible activities of paralegals. They're primarily located in Business and Professions Code section 6450 and the other parts of the B&P code that talk about what document preparers may do. I believe lawyers can do that kind of work. They must, however, be careful that they don't do activities that constitute the unauthorized practice of law, and that they do not hold themselves out as being entitled to practice law through the use of a designation like JD. The California State Bar believes that even calling yourself a JD is a representation that you were entitled to practice law. The average person on the street, if you will, doesn't understand that you may have a JD degree and not be licensed to practice law. So that has been found to be holding yourself out, or is regarded as holding yourself out by the California State Bar. And I think we have a couple of minutes left for any other questions, if anybody has one. Now it's the time to speak. And I'm not seeing any other questions coming into the queue. So I want to thank you all for your attention. I apologize for the interruption, but it's been a great pleasure to speak to you, and I wish you all happy lawyering.